All right, folks, I know this is a little deep dive, but search and seizure is important here in Florida. Most of my drug cases come from the search of vehicles, right? And a lot of those searches are based on a cop claiming, and I say claim, and I should use air quotes, that he or she smelled weed. And when you smell weed in Florida, we have something called the playing smell doctrine, which is a fancy way of saying the smell of weed is evidence that there might be a crime being committed in the car, which gives the cop the ability to search every occupant and the trunk and the purse and the wallet, everything for those illegal drugs. We call that the plain smell doctrine. Yes, I know every search requires a warrant under the Fourth Amendment. But the Fourth Amendment has an exception for cars because you can't have the cop leaving and then you could drive off and get rid of the drugs. So because of the mobility of cars and some other issues with vehicles, the Florida courts and courts across the country have said, we're going to carve out an exception. Cops do not need to go to a judge and get a warrant if they smell evidence of criminal conduct right there roadside. They can search everything, try to find that illegal substance. Well, guess what, guys? Those days are over, and I don't know why we're still allowing searches under those circumstances because we now have legalized hemp. For several years, we have legalized hemp. That means, it's a fancy way of saying hemp is the same damn plant as illegal weed and marijuana. It's the same cannabis plant. They smell the same. They look the same. 7 billion people on this planet with noses and eyeballs, and not one of us can tell the difference between hemp and marijuana. Therefore, when I started criminal defense in '93, in the 30 years I've been practicing up until today, that used to be evidence of a crime of possession of marijuana if they smelled that odor. Now it's just evidence of something perfectly legal. It's just evidence of legal hemp, potentially. So that's what I'm talking about today. The Hatcher case, there's another one, Baxley, that I did another video about. The courts are starting to recognize we can't keep allowing the cops to search a car just because they smell what they think is something illegal, because it could be hemp. I think if everybody that was smoking weed got pulled over and had a hemp sticker or told the cop, I smoked hemp, I don't know where the evidence is then to search the car, quite honestly. But the playing smell doctrine needs to go. It needs to be done. And that's this Hatcher case out of the first DCA. That's what the concurring opinion is saying in Hatcher. This guy was convicted of felony possession of MDMA because when he got pulled over for driving crazy, the cop window goes down, odor of weed. Cop says, I'm searching this van. And they find MDMA. And up on appeal, Hatcher's like, it could have been hemp. You had no right to do this. And the concurring opinion in Hatcher says, you know what, guys? I think it's time to get rid of searches based on the smell of weed when it could just as easily be something legal. Look out, folks. This thing needs to be overturned. Cops should not be allowed to search our stuff anymore based on the odor of cannabis. This needs to go. And you're seeing Hatcher and another case, Baxley, and some others. We're starting to see cracks in the armor here. They're going to take this away. They need to do it yesterday. It needs to be gone. It's happening. And it's just really slow right now. But we'll do another video once they completely overturn this doctrine. And I hope that video will come sooner rather than later.